this stage, this file is the file. This entire second file is the EHM violations. Are you ready on your matter, Mr. Sowards? You need some additional time.
No, ready on Mr. Reigard.
All right, Mr. Reigard, can I have you state your name and date of birth, please, for the record?
Jody William Record, 5/22/1963.
Your attorney, Mr. Sowards, is with us here in the courtroom. Go ahead, Mr. Sowards. What are we doing today?
Thank you, Your Honor. We're here to revisit the violation note from 2Watch regarding the allegation that Mr. Reigard went outside of the geographical boundaries on his electronic home monitoring, that in doing so, he also visited establishments that served alcohol, that he allowed, or that when he submitted his bank records, it showed that his debit card was purchasing alcohol, all which would be a violation of his EHM agreement. Mr. Reigard stated, and I have confirmed, that the allegations as to the R bar, which is Rocky's Pizza, is right next door to his insurance company, State Farm. The purchases on his debit card by his girlfriend are there. He claims that he has not. He states that he in no way consumed alcohol. So we have a lot of arguments and issues there, but the geographical excursions are problematic. We are asking the court to consider the 14 days that he has served in jail as a sanction credit against his EHM. And I think he has about 8. I know I would be surprised if I'm perfectly correct on that, but I think about 8 days. He does have clearance to attend inpatient treatment, and he's just hoping to get on the bed date as soon as possible. We feel that would be easier if he was released today from jail to finish his remaining EHM at home. He could then have a much better capability of communicating with his treatment provider to get the bed date secured and so forth. But that is where the court is today, which is based on the alleged violations. What do we do with his remaining approximately 8 days? I think Mr. Reigard has a better calculation. I don't know what the credit would be for the 14 days in jail, if that gets the 15%. So there might be a day or two leeway there.
I mean, I guess what I would say is the court doesn't have to give him, I have to give him credit, but I don't have to give him the same sanction. The court's not limited to the EHM sanction that's been put forth. The EHM sanction is oftentimes extended in lieu of jail as a privilege, not unless the court has no jurisdiction, unless I give someone 364 days, the court always has latitude. This court has always viewed electronic home monitoring as a privilege that is extended to a person who has the maturity and the awareness to be able to follow what I believe are very simple guidelines. And I think that the court, in looking at this gentleman, it's not like he violated the EHM once. At this stage, this file is the file. This entire second file is the EHM violations. So it's not like he did not have any notice. It's not like no one was telling him that these were violations. So I don't have to give him credit. I'll give him credit towards the 364, but there's no situation where this court has to keep coloring within the lines of the sanction he received as what was extended by the city as a privilege to avoid a jail sanction that he chose to not abide by. So I'm going to be, there's not a situation where I'm going to have to do a credit calculation unless it's up to 364 here based on his chosen conduct. We live in an age where you don't have to go to your insurance office. I'm sorry. It's just not the way that the world works now. Whether it be something that can be done over the telephone, which can be something that can be done via email, I don't buy it. And that isn't in a proximity to a location that serves alcohol. So I don't buy it. And the fact that he is going out and violating his EHC and purchasing alcohol for his girlfriend, but is telling the court that he has an alcohol issue that is pronounced and severe enough to need inpatient treatment, I don't buy it. I don't think that anything that Mr. Reigard said, I don't believe, because he's been extended the court's courtesy and he has chosen to not do the things that he was supposed to do multiple times. Mr. Busby, go ahead.
Thank you, Your Honor. The city would ask for that no further EHM be authorized, that everything be converted to jail time. As the court noted, Mr. Reigard, regardless of alcohol consumption, EHM is a penalty. It is a confinement that was asserted and statutorily required. And he has essentially said, I don't need to abide by that. Frankly, he could be charged with escape, I believe, at this point, given the repeated and consistent violations and deviations from the EHM requirements. Essentially just a complete disregard. He's gone wherever he wanted, including places that serve alcohol. So it is extremely concerning to the city that essentially Mr. Reigard said, I don't have to follow the court's order and I can do whatever I feel like and I'll go wherever I want and EHM doesn't apply to me. And then proceeded to essentially try and give, I would agree with Your Honor, phony excuses as to why. And so I'll defer to the court regarding additional sanction, but absolutely, city is not supportive of any further opportunities for EHM. The entire sentence needs to be confinement in jail, and arguably, I believe, for the number of days that he simply didn't obey EHM, those shouldn't be credited as completed days of his sentence.
I think the thing that is going to be the most, I think the situation of what the court wants to get right is I do want to provide credit for days where the EHM was abided by. The difficulty is going to be assessing how many days were abided by, how many days, and then based on what the court had sanctioned before, what the proper remaining balance would be. I think the court is not going to provide EHM credit for days where there were violations. I think that the homework that the parties are going to have to do, certainly the court will also look into this, in going through the litany of documents is going to be where we fit in that calculus. Now, I don't know if anyone has done those calculations yet, but I would, in choosing what the sanction is going to be, I at least want to get it right. I don't know if right now we have the resources and time to necessarily make that calculation right now.
You know, I think the record I have can get us there because we have his 2 watch records of when he started. The question would be the 14 days he's been in custody since his last court date. Is that a sanction or a credit against EHM?
In my eyes, I would want to understand what the remaining balance is. And I know that doesn't sound like a fair answer, but if he's going to be getting out in 6 days, it's probably a sanction. If he's going to be getting out or being released in 30 or 40 days, it's probably going to provide credit. My circumstance is that I believe that he is a profound safety concern, I'll say that twice. Because I believe he's a profound safety concern, I am more comfortable releasing him to an inpatient program or releasing him within a day or two prior to an inpatient program than just saying that the math works out in such a way and I'm going to leave you untethered in the community with an alcohol issue that he is acknowledging for multiple weeks.
The records, Your Honor, are on my laptop and in front of you. So if I could have the file, the question would be, would you ask us to have the jail keep Mr. Reigard available for maybe another 10 minutes while we do some basic math?
Yeah, that's fine.
If Madam Clerk would make sure the jail knows not to take Mr. Reigard back, we can probably get those numbers for you.
Would you like the court files, Mr. Sowards?
Yes, I'll need those things.
So, Mr. Reigard, this is how we're going to do this. You originally sanctioned to 60 days of electronic home monitoring. You had completed, based on the math provided to this court, 38 days. 14 of those days, there was violations filed. The court is not crediting you towards home monitoring on days where you are not properly participating in home monitoring. As a result of that, the court is going to credit you for 24 days of EHC that was properly completed. That would leave a balance originally of 36 days. The court has sanctioned you to 14 days in jail, which the court will credit towards those 36 days. This leaves a balance of 22 days. The court is going to modify the sentence from 22 remaining days of electronic home monitoring to 22 days in jail.
If Mr. Reigard is able to arrange for inpatient treatment, maybe he released to inpatient treatment directly from the jail.
Your Honor, the city would oppose that at this time. Mr. Reigard has not shown that he is willing to actually follow through with the promises he's made to the court. The city's concern is essentially he's going to get a bed date and then either not show up or leave early. Once again, we'll be back bringing this matter before the court. I think he can wait until after he gets out to follow through with that.
I think because the sanction was a mandatory minimum sanction, it can't truncate the EHM. So I'm going to impose 22 days of jail. Certainly my hope is for Mr. Reigard on the 23rd day he goes into inpatient treatment, but the court certainly can only maybe suggest that step. But he will serve 22 remaining days. These are a mandatory sanction, Madam Clerks, for whatever JNS is provided to the jail, meaning this is not a circumstance where good time is imposed because this was a DUI conviction. Okay. I'm going to set a review date to check on Mr. Reigard's progress with the drug and alcohol evaluation, recommended treatment, victims panel if that's not been completed, and all other conditions on his case. That mandatory date is going to be on the 16th, of April 2026 at 1:30. Certainly, if the court receives documentation that Mr. Reigard is in an inpatient program, I can excuse his presence at that time. Thank you, sir. That concludes your hearing.